Okay, good afternoon. The church bells are ringing here, so I know it is exactly 1 o'clock. Great to have you back with us. This is our last session of the afternoon. We hope you are fed and watered, possibly even caught up on a couple of emails. And this is a great session because this afternoon, we get permission, even encouragement to complain in this next session, but please listen carefully for how you can effectively complain so that it's solution oriented. We have a great team presenting to you. First off, we have Howard Belladot, who has focused his law career on public interest cases, specializing in civil rights. His advocacy has impacted tens of thousands of Idahoans, really, and has established case precedents of national significance. We are very lucky to have Howard in Idaho. For over 40 years, Howard has served as counsel seeking to enforce consent decrees in Jeff D. versus Little, which requires the state to provide a full array of mental health services to children with severe emotional disturbance. Many of you will be very familiar with Jeff D. Howard is currently involved in the implementation of the Jeff D. settlement agreement in Idaho's system of care. He has also challenged the commitment of children to the state hospital without a hearing, confining mentally ill persons in jail while waiting for commitment hearings. He recently received the 2021 Idaho Bar Distinguished Lawyer Award. Prior to that, there have been other impressive and well-deserved state and national awards. We're very lucky to have Howard in Idaho and lucky to have him with us today. Joining Howard will be Kimberly Hokanson, who is a parent with over 20 years of experience personally navigating Idaho's children's mental health system. In the past 10 years, she has served in many advocacy roles for both government and nonprofit entities, including being a board member for the Idaho Federation of Families. When I first started here, Kim's been a really important person and resource to me in my time here. Yesterday, we mentioned that one of our parent speakers was one of the 5 original parents to be contracted by the Division of Behavioral Health as a parent consultant, and Kim is another one of those experienced veteran parents as well. She's been a member of the Idaho Behavioral Health Council's advisory board. She currently holds various roles within the Youth Empowerment Services, or YES, as a parent advocate. And she chairs the State Behavioral Health Planning Council and is a member of Idaho's Juvenile Justice Committee. She does all of this while supporting her 4 children's behavioral health needs and nurturing their ongoing desires for fun and some new experiences. So basically, Kim's an Energizer bunny, and we love her for that. Kim and Howard, please take it away. And Michelle and I will be monitoring the chat for any questions, and we can share those at the end. And I will put up the first PowerPoint, and you guys just tell me when to move that along for you. So let me share screen. All right, I believe we are good to go as soon as I full screen it. Okay. All right, take it away.
Thanks, Ruth, for that introduction. I want to thank everybody for joining us today for our topic. And the complaints, I started a poll and I asked if anybody had ever not complained because of any reason, really retaliation or embarrassment or anything of the sort. It was interesting because 10 people obviously did decide to not file a complaint, even though it would have been appropriate. And then 5 people have never not done that. So in today's society, it's very interesting to take that into consideration because now people are referenced as Karens when they complain. And so today, what I want to do is kind of go through the complaint process and really emphasize the importance behind it and the purpose that it serves in looking at the entire system. So if we can go to the next slide. So as we see, many families experience the frustration and grievances while navigating YES. The frustration can be brought on due to barriers, denials, access, lack of appropriate services, and so many more things. A lot of people don't understand that they can file a complaint, and at the same time, they're fearful of filing a complaint. So we'll go into all of that as well.
I'm sound off, but I have no way to, every time I move my.
Ruth, I can
sorry.
Okay, next slide, please. Okay, so anybody can file a complaint. It can be a parent, it can be a youth, it can be a provider, and the more complaints that are made, the better. So it's not specific to just families and parents. Really, anybody can access the complaint line and complain, especially if you're experiencing a provider that is super frustrated with the ins and outs of how to provide a service, and they're finding that they're unable to provide the service because of certain maybe rules or barriers through Medicaid or their MCO, which is the Managed Care Organization. I'm going to try really hard to not use acronyms. And so they can lodge a complaint, and all of them are looked at. Next slide. Okay, so who and what complaint can be made against? So as I was mentioning before, really anybody can, but the nice thing is the complaint can be made about anything. So it's not specific to just, yes, it's not specific to just Medicaid, it's not specific to just DVH or Division of Behavioral Health. It can also include the State Department of Education. It can also include juvenile justice. It can also include child welfare. It can include the developmental disability side of things. We have seen complaints that vary from all of those areas. So as long as it pertains to your kiddo's behavioral health in any way, shape, or form, then the complaint can be made against anybody, and it's taken to the appropriate people. And we'll go into that further later. Next slide, please. Okay, so there's a lot of different ways that you can file a complaint. So there's the YES website, which is Youth Empowerment Services website. I do provide that link later on in the PowerPoint. You can call in your complaint, you can email your complaint, you can obviously go through the Idaho Federation of Families because they're really heavily involved with the state. And you can also attend a Quality Family Advisory Subcommittee. And I'll go further into all of these during the presentation. Next slide, please. Okay, so on the website, there is the website, yes.idaho.gov. You can go to the contact section, click on concerns and complaint link, complete the form to your liking. You don't need to include your personal information if you want to stay anonymous, and you can submit the form. And for the sake of this presentation, I actually did go ahead and submit a complaint anonymously. And so my complaint was obviously how many things I had to click on to find a way to submit a complaint. So it was ironic, but yeah, so that was pretty easy, but I did ensure that you can remain anonymous on that. So filing a complaint via the phone line, that is the toll-free number that you can call. You'll be connected to a message. I again went ahead and went through the steps to verify that this is the procedure. So you'll be connected to like a voicemail almost, but it's not technically a voicemail because it doesn't ever fill up and become so full that it can't bring on any more. And you can provide your contact details within this, or again, you can remain anonymous. I think, yeah, there we go. Okay, so then there is also the email option, which seems to be really convenient for a lot of people because we are all very busy. And so that is the email address, and you can title the subject line so that they know exactly where it needs to go. And it's a little harder to remain anonymous, completely anonymous. This option, but you still can, right? Like if your email address is not really affiliated with your name in any way, you can just leave your name off and type into the complaint that you wish to remain anonymous, so you do not expect a response back from them. So then they don't reach out to you again. Okay, timeline of submitting a complaint and what to expect. So this really depicts what it looks like, and I'll kind of walk through this, but you can read this on your own. So initially, someone from the Division of Behavioral Health will reach out to you, and they will have you they'll engage you in a conversation around your complaint to kind of glean any more details that may be necessary. And then they will escalate your complaint. So at that time, you can really talk about really details, because I know that as a mom, I find that a lot of my issues within a system seems multi-pronged. And so it can touch multiple different systems. And so I know it seems like a big jumble of information, and sometimes having that conversation and engaging with that person makes it a little bit easier for me to connect the dots for them as to really how all of the different areas are affecting my child negatively, and really what I would like to happen moving forward. So at that time, they will also ask you what it is that you want to happen from your complaint. So you can look for a resolution, or you can just let them know you just wanted it to be documented that this is an issue. If a resolution is desired, then the Division of Behavioral Health representative will escalate it to the appropriate party. So for example, if there is an issue with a CMH worker, then that issue would be taken to the chief of that CMH department in the region. And then they will come back to the Division of Behavioral Health representative with the resolution that occurred from the action. And then you will be contacted and notified of that resolution. And all of this really should be happening within 30 days. And that is from the date that you actually submit your complaint. So not from the date that you're first contacted. Next slide. Okay, so filing a complaint through the Federation. You can reach out to the Federation. Obviously, there is their contact information. I'm finding that they're either pointing parents in a direction that they can go to take the next steps for their complaint, or even seek resolution of their issue themselves, or they can bring your issue in front of the appropriate representatives on your behalf. Next slide, please. Oh, and there is more information. And obviously, this is a great way to remain anonymous as well, while being supported with a one-on-one person and engaging in a conversation with you. Okay, so filing a complaint through the Quality Family Advisory Subcommittee. So this subcommittee was created as a work group underneath the Quality Management Improvement and Accountability Council. So the reason that we did this is because, and I'm going to call it QMIA now, so Quality Management Improvement and Accountability. The QMIA Council really has to capture what is occurring in the system, whether that's good or bad. And with that, we were finding that the most meaningful stories that could be brought, and examples that could be brought of how a system isn't working is through the families and the stakeholders, the providers. So a group was created to provide a safe space for anybody to join and provide their stories. So instead of going to a council, it's a smaller group, and it's heavier with the stakeholders already on the group. I myself am on that group. I have another parent that's on that group. And we have Candace Falsetti, who really creates a lot of our quarterly reportings and other aspects of quality management within Youth Empowerment Services. So we have all signed an agreement that obviously stories would not be shared without the permission of the parents. It is a confidential group, so it was really set up to make parents and stakeholders feel very comfortable and safe coming with their specific stories, especially when we can take pieces and parts of their stories and identify the system barriers. So I encourage anybody that would like more information on this to absolutely join this group if you're finding that you're hitting a lot of roadblocks and barriers in accessing care for your kiddos. Okay, so now we'll go into how the complaint serves the system. The purpose of the complaint process is to not only have your voice be heard, but also inform and improve the system of care. All complaints are documented and tracked. The complaints are filed and tracked anonymously before they are documented, categorized, and escalated. The QMIA can share identified issues within their quarterly reports and will, oh, there's a typo, that's nice. Nope, can we go back? Thanks. So when we identify issues, and I'll use Kansas, a specific issue that was really brought up through QFAS, the Quality Family Advisory Subcommittee, they created a whole separate work group because all of the different pieces and parts that were identified as not working with the CANs for families and the youth were disseminated and escalated to all of the appropriate people, representatives. So we ended up having to take that not only to Optum, but to Medicaid and to the Division of Behavioral Health. Medicaid also contracts with Liberty, who also provides CAMS assessments. And so with that information, we were able to create another work group specifically called One Child, One CAMS. And that is one of the examples of how this complaints process can really benefit the system, because slowly but surely that issue is being addressed, and most importantly, it's identified. A lot of parents were going through and finding, I just heard a story just the other day of a parent telling me that the provider asked her to rate each section of her CANs on a 1 to 3 scale. So that's completely not how CANs works. That was also identified, and because of that, a lot of that's going to be used to help inform providers in future trainings on the CANs with the support of the Parade Foundation. So all of the complaints really do call attention to the issues. It may not be every single issue identified within each quarterly report, but it is raised and attention is brought to it. And there's a lot of accountability with this complaints line, which is really nice. Next slide. Okay, so that is the end of my presentation, and I will open it up for questions.
I'll encourage people to put questions in the chat really quickly if you have any before we move on to Howard's section, and I'm going to cue that up here in just a minute.
Okay, well, thanks everybody.
Thank you, Kim. Howard, are you good to go? I've got your...
Okay, I got it.
Yeah, perfect.
Thanks, Kim. I think I'm gonna have to get some tutoring lessons in PowerPoints from you. Mine aren't that exciting. And I do want to reiterate and support the idea that it's very important for everyone to make these grievances and complaints, because they do make a difference. And it's one way that they monitor the quality of the services that are being provided and the system itself. Well, let me thank everyone. Happy to be here today. I remember when the Federation started, it arose out of the Jeff D litigation, and it really over the decades has made a tremendous impact and developed into a strong voice and advocacy organization for families in Idaho. And we work closely with parents and the Federation as part of the implementation of the Jeff D settlement agreements. And it's really critical to have their voice at the table, because you actually experience it. And I do think it has a tremendous impact in our meetings. So I'm going to cover what happens after you get a notice of denial from the MCO and you've exhausted the MCO's appeal process, Optum's appeal process. You have to, if you get a denial from Optum, they'll tell you how you can appeal it, and they'll review it. You have to do that before you can take it to the next step, which is a state fair hearing. And I'll take you through all that. One thing you should know is this is a little complex. It's all based upon state and federal law. Medicaid is based upon federal regulations, which the state is required to follow. And the state ADAPA regulations with regard to appeals. And in some ways they're not exactly the same. And one of the things that we did in Jeff D was to raise this issue of the entire what we call due process procedures. What's required? It's required under the United States Constitution that you can't take away somebody's services, which is a property right, without providing them the ability to have notice and a meaningful opportunity for hearing to challenge the denial. Okay, go to the next slide. So we came up with this authoritative due process protocol, and it's on the YES website. It's a little bit complicated, but all of this presentation is basically taken from that, because it has the state and federal regulations, and then it talks about what the settlement requires, and then it kind of sums it up. So that's the source of this, and I'm going to try to make it less complex as much as I can. And I see I made a clerical on myself in the second line there. So, so the protocol outlines the procedural due process as required by mostly the federal requirements in the Medicaid Act. And so I listed that CFR, those two CFR sites. Those are the relevant regulations. And the rules governing contested cases is the state administrative regulations. And that section below there is the YES sections in that, because the rules, contested case rules cover all of health and welfare's programs. Next slide. So this is, if you go to the protocol, you'll see this is the index. This is exactly what it looks like. And there actually you'll be able to link to each one of those different things. I put it in there because it gives you a good outline of what exactly is going to happen if you want to file an appeal. Next slide. So You're going to get notice if you get a denial of your right to request a fair hearing appeal. It must be in plain language. We've worked on that, and accessible to individuals who don't primarily speak English, and to individuals who have a disability which would prevent them from understanding the notice. That's a federal requirement. Now, the written notice has to have certain elements. First, the right to have a fair hearing, and the right to have an expedited fair hearing. There's two types of hearings, standard and expedited. I'm going to cover that in a moment, the expedited fair hearing. The method to request a fair hearing, how do you do that? The individual that the individual may represent themselves, have legal counsel, or have a friend or a spokesman. You can see if you can get somebody from the federation, and the time the agency has to take final action, which is 90 days from when the date of the appeal is requested. Next slide. Okay, so when can you request a fair hearing? The department has to grant an individual request if there's what they call an adverse benefit determination, ABD, right? That's just the technical way to say a denial. And what that actually means is a denial or a limited authorization for a requested service or level of service based upon medical necessity. In other words, if you think you needed more hours or you needed the services that you think were necessary, the appropriateness of that, or the effectiveness of the service, you can file a notice of appeal. A lot of times it's reduction in service or a suspension of previously authorized service. So it's not only a new service, but if it's they reduce the service that you get. The other things, denial of payment, failure to provide it timely, the managed care organization's failure to respond to a grievance or appeal, and especially in those areas of Idaho which have limited accessibility to providers, the denial of a request to obtain services outside the MCO's network, and denial of request to dispute financial liability if there's a copay or something. Next slide, please. Additionally, presumably everyone who's going to be doing this is a class member of Jeff D, has a severe emotional disturbance. So you have a right to assert what is the state is required to provide you under the settlement agreement, the service and support crosswalk, the principles of care, or the practice model. Now, the crosswalk, that's going to be created as part of the implementation assurance plan. So it's not there yet, but it will be created shortly. But if you're not familiar with these things, you should go to the ES website and just review it. It gives you, there's a lot of good information on the ES website of the services that are available, what the department's supposed to do, and what you're entitled to receive. And you don't really get that. They don't really give you that. A lot of times you ask for the service, you go to a provider, they provide some services. Next slide, please. So if you get a notice of denial of a decision or adverse benefit determination, it must be provided 10 days prior to the termination, suspension, or reduction of the services. So you're not immediately cut off. They have to give you at least 10 days. And from the date of that notice, you have 28 days when the decision is mailed to request a fair hearing. So that's important. It's not when you receive it, it's when it's mailed. So it has to be postmarked. If it isn't postmarked, you probably look at the date on the notice. It's very important that you you file your notice of appeal within 28 days, and the decision will have a form to do that, and it will also tell you, how to do it as well. So that's the first thing. Forget everything else. Get that notice in, because then you'll have time to prepare. Next slide. So you can do this by telephone, internet, mail, in person, any electronic means, fax or email, any way, and it will provide you with the notice will have that information on it of how you can do that. One thing I wanted to mention, previously the department was requiring people to require supporting documentation when the appeal is filed. Well, a lot of times you don't have that. You don't even know what was considered to make the decision. You may not have ever seen it. The provider may have it, Optum may have it, but Liberty may have it, but you don't have it. So you don't have to do that anymore. And you don't have to send them a copy of the notice of decision to continue with your appeal. I could never understand that decision. It's their decision. Why do you have to send them a copy of it? So that makes it easier, a little bit easier. Next slide. Now, this is the expedited appeal. This is standard appeal. Typically will be heard within 30 days, unless you ask for an extension. But if you need an expedited appeal, because the 30 days could, and this is right out of the federal law, jeopardize the individual's life, health, or ability to attain, maintain, or regain maximum function, you can ask for an expedited appeal. The notices, the Medicaid notices will talk about, danger of death. It's not that. You don't have to be in danger of dying. But if you have a serious condition, and you don't need a provider to say this, you can say it. Now, it's helpful to have a letter or something from the provider to support the need for an expedited appeal. You can request it, and they can accept it, and you'll be heard within 72 hours. And if they deny it, your appeal will still continue. So it's worth doing if you think it's really necessary. One of the things that you should pay real attention to, next slide, is the right to continuation of benefits. So you have a right to request continuation of benefits. So in other words, you're not cut off until after your appeal. And you should always do that. The one thing I will tell you is, if at the end of the appeal and your appeal's denied, the state can come in and try to charge you for the continued cost, for the cost of the continued benefits. But this never happened. So there's really no downside. They're not going to really charge you for that. So I definitely would encourage you to do that. And you can also ask to be reinstated, have your benefits reinstated until the hearing decision is made, if the request is made not more than 10 days before the effective date of the action taken. Or if you did receive notice. You find out because you go to a provider and say, well, you're cut off, but you didn't receive notice, then you have a right to continue benefits, and you should contact the department right away and say you didn't receive notice, either because you moved or you got lost in the mail or whatever. Next slide. So the notice of the hearing must be provided 10 days in advance, as I said, and the notice must provide, well, actually, the notice of the hearing is different than notice of decision, but it's both 10 days in advance, or 10 days in advance of the termination date for the decision, 10 days in advance of when the hearing is. Typically, it's longer than that. The notice must provide you the time, place, and nature of the hearing. So the hearings nowadays are all telephonic. So it's all going to be conducted over the phone. With regard to what the information you're going to get, you get the statement of legal authority for the hearing. In other words, the state regulations, the federal regulations. Okay, particular sections of the statutes or rules involved. Medical necessity, for example. They will tell you it's a question that you don't meet the medical necessity requirements. The issues involved. What are the factual issues? You don't need that number of hours. You don't have that severity. It will also again remind you of your right to be represented by an attorney or a non-attorney or someone of your choice, and how and when the documents for the hearing will be provided to all parties. The documents are going to be basically the records and anything you want to submit. These hearings are conducted by the, it's supposed to be an independent office of the Deputy Attorney General within the Fair Hearing Unit of the Office of the Attorney General. So they're all Attorney Generals, but they have to be separate. So there's a Fair Hearing Unit that hears these things. And the hearing officers are attorneys. Next slide, please. So as part of the hearings, you have certain rights, and they have to be provided to you. The first thing, and one of the most important things, is your right to get all the records, all the department's records that they considered, and any of their contractors, whether it's Liberty or anybody else. So you get to examine the context of your case file. So in other words, all the people who worked on it, who are department employees, they have electronic case files. There could be emails that you might want to get. So you're entitled to all that. You're entitled to all the documents and records used by the state at a reasonable time before the hearing and during the hearing. So in other words, you make your request and they have to give it to you, but you can't wait till the day of the hearing, because you obviously, it's not very useful. You have to review them, and you may have to show them to somebody. You may need them to prepare witnesses. You may need them to prepare your own testimony. So you gotta make sure that you get the documents. And if you don't have, they don't give them to you in time, you should notify the hearing officer that you're not prepared. You need a continuance because they have delayed giving you your documents. You have a right to bring witnesses. That can be any type of witness. I know it's difficult sometimes to get a provider to take part in this type of hearing, but they can write something up in support of your issues, why it's necessary. You want to make sure that one of the reasons why you get documents is to make sure they had all the records. They considered all the records. There may be a time lapse between certain records that the department received and reviewed and what is transpired after the fact. There may have been a crisis of some sort that they're not aware of. And so it's important for you to review all the records and make sure that everything that will support your case is submitted to the hearing officer. So at that hearing, you get to testify. If you don't have an attorney, the hearing officer will basically lead you through the issues and may ask you questions, but you're allowed to speak as well. You don't have to wait for the questions. You know, these hearing officers, they're all a little bit different. There is no set formula, so that they all may run it a little bit differently. If you're represented by an attorney, it is a little bit more formal. They will probably call you as a witness, and then your attorney will ask you questions, and then the attorney for the department will be able to ask you questions as well. And then you get to make your arguments, why you think the department's decision is incorrect and should be reversed. You should be able to question anybody who's making that decision. The one thing I noticed a lot is they don't really bring the people who make the decision to the hearing. They bring somebody who's going to tell you what the decision is. Well, it's impossible to question a piece of paper if they just submit the paper as to, well, did you consider this? You didn't know this, did you? Those types of questions. Did you talk to so-and-so? You can't do that if they're just going to submit a report. And so you can ask for the department employees who made the decision to be there. You know, if it's Dr. Hanso, she should come and be able to defend her decision. You know, or whoever made the final decision. I actually think if some of these decisions were challenged, that they would be more careful in making it. But it's kind of like a check, and they don't really get checked too often, because it is difficult for parents to do this. And I do know that Kim and other parents have helped individuals through this process, but it's not easy. It really isn't. And so getting help is important, especially when you're just unfamiliar with this whole process. I've represented parents before in these, and so I know exactly what even the most sophisticated parents, the most knowledgeable parents, this is kind of like out of their bailiwick. Next slide, please. So this is something that's actually really important. There's a legal term. It's called burden of proof. And in other words, who has the burden to show that the decision is incorrect or correct? So, and the standard for that is the predominance of evidence. And all that means is that you're more likely, like 51% more likely to be true. So in other words, you don't have to show it's absolutely true, 100%. It's just more likely than not. So anything over 50 is more likely under the preponderance standard. So if the department is limiting, reducing, or terminating services or benefits, or establishing an overpayment or some sort of disqualification, they have the burden because they're terminating existing services. So if you're a recipient or eligible and they're reducing it or taking away, they have the burden. And you need to remind the hearing officer of that, because I've seen that where I don't think they recognize that. Now, if you're just applying for a new service or something, then you're going to have the burden for eligibility or for that service. And that is a hurdle. That is a heavy burden for people. But putting it on the department, in my mind, makes it easier. So you have an advantage when the burden's on them, and you remind the hearing officer of that. But you don't have to prove you're eligible, but they have to prove you're not eligible. Next slide. This is about the document request, because this comes up in a lot of cases. And sometimes they say you have to make a public records request, which you don't. It's right in the federal law. You're entitled to it. It's not a public records request, but they like to keep track of things, and that's the way they keep track of things. So they may make you fill it out, but they shouldn't. But it's not worth fighting over. Just do it. They have 3 days to produce it, and typically they can't get it done within 3 days, so they have to send you a notice, and it's up to 10 days. But again, if that delays things, so you cannot properly prepare, then you can ask the hearing officer for a continuance so you can prepare or line up your witnesses if your witnesses can't be available on the date that's chosen. So, as I said, you're entitled to access to all documents consulted in making the decision, and that's whether or not the department relied on it. So in other words, they can't just cherry pick the documents that support what their position is and ignore the ones that said, no, from your provider, no, I think these services ought to be provided. You're entitled to everything. As I said, they need to be in advance. There's no cost to you. They can maybe ask you for a verification, but you're not charged. They should be getting these documents. You can ask for witnesses. You can bring witnesses. You can ask the department to bring employee witnesses without a subpoena. As long as it's persons with knowledge. We've been told that you won't need a subpoena for department employees. You have a right to ask the hearing officer for a subpoena if you need to bring a third party there. I don't know if they'll issue it or not. They'll probably want to know. Witnesses don't really like to be subpoenaed. They like to, and you really don't want to subpoena someone because right away they're going to be against you. But if you have a provider that you want to testify, they can just get on the phone, set up a time, and they can get on the phone and give their testimony and be done with it once they're done. They don't have to. It's all by phone anyway, so they don't have to leave their office. They can set up a blocker time for it. Next slide. Now this is a very important right, and this is only in federal law, the Medicaid regulations. So parents tend to be at a very disadvantage for a lot of reasons. But one of the big disadvantages, they'll get somebody from Liberty or their medical director said it's not medically necessary. And you don't have anybody who has the qualifications to dispute that opinion of them. Your opinion is not going to override the opinion of the medical director, who's an MD, even though she has no experience in dealing with mental illness or children. But she's the medical director. She has MD next to her name. So you have a right, and I don't know if anyone's ever done this before. We had one case in which we did get an assessment, an outside assessment, but to ask the hearing officer to appoint a independent medical person to give an assessment of the needs or the services that you're contending you're entitled to receive. So it's independent, and typically it can include somebody who actually spends some time and evaluates the child, as well as review the medical records. And the best part of it is the department has to pay for it. Typically Medicaid would just pay for it like any other services. And that's the regulation there. I gave it to you right there. If the hearing officer needs to know it. The hearing officer will get a copy of the due process protocol under the agreement. So they're going to have all of this laid out for them, but you got to make sure to request things that you're entitled to. And you can, you know, it's like, I think it's like 25 pages. Just bring it with you, and then you can point to things and say, well, I'm entitled to this. Department agreed to provide this right here, hearing officer. And they have not been, in my experience, the hearing officers have not been enforcing federal law. They just look at the state law, and there isn't much in the state law. There's a definition of medical necessity, and that's it. And then it's up to the department to interpret that, Medicaid, you know, and they're going to interpret whatever they're going to interpret, and they're going to look at records, and you know, records are going to be ambiguous in a lot of times. You know, there are good days, there are bad days, you know, and you're going, well, the kid just, you know, I've been attacked. I mean, this kid needs more services, maybe out of home placement, which really is difficult, as many of you know, to get. Next slide. So after the testimony and the hearing, which is recorded, and everybody's placed under oath, you're going to get a decision, and the decision will be written, and it's going to summarize all the facts, the testimony that the hearing officer considered, and identify the regulations supporting the decision. So it's going to cite to the Medicaid regulate rules and what the applicable regulations are. And then it's going to make a decision. Now that decision has to be made ordinarily. There are some exceptions, but they don't really apply except in a special case. Within 90 days from the date the department received the request for a fair hearing. This is something that I have found the department doesn't do, and they're required to do it, and they just can't hold a decision. I have one case right now. It's going to be a year in July. No decision yet. It's not a injected kit, but it's the same regulation applies. And I'm gonna be challenging that in a separate case. So they have to do that within 90 days, and typically it's not a problem. Where it may come up is if the hearing officer decides it needs more evidence, or there's another reason for denying the services, or that they got new evidence that needs to be considered, and they remand it back. You still have to make that decision after remand within that 90-day period. And if they don't, you should file a new appeal saying they're in violation of federal law. So you're going to get what the hearing officer will give you is this, what they call a preliminary order. That's the decision. And under state law, they get a preliminary order, and then after it's issued, it can go to the director of the department to review. And the director of the department makes a final decision. Well, that makes no sense, because the director of the department doesn't do any of this. They got somebody there, an attorney, that will write it up, you know, and basically they uphold whatever the hearing officer said. But that's the way it is, and you got to get the final order to exercise your right to file a petition for review in the state district court. That's the procedure to challenge a decision on the appeal. That's kind of difficult to win. So it's better to win it in the fair hearing level. So the preliminary order will be issued within 30 days after the testimony is taken. It includes specific findings on all the major facts, a reasoned statement to support the decision, other findings and recommendations of the hearing officer, and then the decision will affirm, reverse, or modify the department's decision or action, or remand it for further proceedings, as I said. It will also include the procedures and time limits for filing requests for review of the order. That's to the director. So it's all going to be in that decision. They usually lay it out pretty well of what's required and why they made the decision and what they relied upon. So that's the administrative review process. And like I said, you have a right to file a petition for review in state court, but that's pretty difficult because the standard is very high. They'll just affirm anything when there's what they call substantial evidence, and that's just really any evidence. And it doesn't matter if you presented conflicting evidence or different evidence, it's still substantial. You can't just question it because you put a different version of the facts. So taking it to a state court, unless you have some error in the way the appeal was processed, I don't think you're going to win. Unless you can really show a violation of federal law, that also might be a question. So I'm done with what I have to say, and I'll answer any questions.
Thanks, Howard and Kim. Let's see, I think we have a couple questions in our Q&A. Yes, Kim, there's a question regarding QFAS, when it meets, how a parent can access QFAS.
That is a great question. So typically we meet the third Tuesday of every month. This month we're actually meeting the last Tuesday. I would assume that the best way to get more information as to dates and times on a monthly basis would probably to reach out to the Federation.
Yeah, and that would be totally fine. We have representation at that meeting. We keep track of when it is, and we can either represent you at that meeting or support you in attending that meeting. So another question is, are you saying, let's see, I'm not sure if this is going to Howard or, yeah, I think it's probably Howard. Are you saying that the department can ignore the licensed clinical professionals who have concluded a certain service is medically necessary for a specific child? Does the department assert that they get to interpret what medical necessity is that matches the child's symptoms?
Yes. The short answer is yes. Doesn't make it right. Okay. But that's worth an appeal, because I would argue the treating provider who has seen the child for X number of months or years even, has interviewed the child, has interviewed the parents, maybe some collateral sources like at school or other providers. I think that carries more weight, and that's where the burden is more important. They should have, they would have the burden to show that that provider is wrong. And then, you know, the parent gets in there, they don't get to make clinical determinations, but they're there to give facts. This is the behavior, this is what's happening, this is what I found, this is what was said. The department doesn't have access to any of that, you know? And so, yes, that's what they do. And so that's why you file an appeal.
Thanks for that. So if you have a question on your individual situation need, please make sure to let us know at IFF and see how we can help and support you, because it's hard to answer globally for what frequently are individual situations, but I will give us a shout out that we're pretty good at individual situations. And we're lucky to have access to people like Kim and Howard to help us with individual situations occasionally and guide us. I don't see any other questions at the moment. So, and we're right at time actually, so I guess that's perfect. I would like to say thank you so much to both Howard and Kim. They are such important collaborators, advisors to IFF. I can't tell you how often we pick their brains for various things, and all in our attempt to support you, parents, as best we can. So thanks for your help with this presentation today. Let me remind everybody that we start at 11:30 tomorrow morning. We have a psychiatrist joining us, and his presentation is called Framing a Child's Distress and Behaviors to a Physician. So that is about the dialogue between parents and physicians regarding their child's mental health behaviors, and what it's helpful for physicians to hear and know. And that will be an interactive conversation at the end. And then after that, we have a parent panel. So that's the ultimate in parent voice, right? Is to hear directly from parents who are working in the system actively, parents like Kim, maybe not quite as busy and extended in the system as Kim, but parents who have involvement on various, work groups, state or local or regional panels, councils, et cetera. And so they will be presenting to you and offering you the opportunity for a Q&A. So thanks very much for a great day too, and we will look forward to seeing you tomorrow. I don't want you to forget the Tube Guy is available to all of those who are out there connecting. If you don't know about Tube Guy, I'm not going to go back into Tube Guy, but he's very near and dear to my heart, and he will go to a new home based on those of you who are actively connecting in Huba. And some of you will also get our nice tote bag that's from Mental Health Awareness Month. And so keep up the great connecting, because that's also what this conference is about. And if you're enjoying your social connecting in this conference, please know that that's exactly what we try to do for parents. So stay with us after conference. Let us know you're interested in connecting with other parents, because we have a whole host of ways for you to do that through various things we have going at the Federation. So have a great afternoon, everybody, and a good evening, and we'll see you in the morning. Thanks so much.
Thanks, Ruth. Thanks, everybody.
Bye.